11. This is part 2 of the residential purchase agreement. And those of you that are online can download a copy. If this is your first time, when I highlight something in red, it usually means that it does mean it's a contingency. And when I do things in green and blue, those are things that people are supposed to do. Buyers are supposed to do, or sellers are supposed to do. And it's generally a good idea for you to know, if you represent the buyer or the seller, what things in the contract the buyer and the seller shall do, right? What is their to-do list? So condition of the property, unless otherwise agreed in writing, it says the property is sold as is in its present physical condition. I see agents putting this in the MLS, property to be sold as is. I see agents wanting to write it in the other terms section of the residential purchase agreement. I sort of have a philosophy, which is if it already says it in the contract, then don't write it in. Right? If it's already saying it, and I've had some agents say, well, what does it hurt if we write it in? A lawyer will tell you, at least they've told me, that if you start repeating or modifying some of the words in the contract, they assume you had a purpose for doing so, and that somehow you wrote that there to change something that's already there. And it sort of sounds dumb for you to say, well, I just wrote it in because I thought it was a good idea, even though it's already in the contract. So the contract is an as is contract. What as is means is not that the seller doesn't have to tell the buyer what's wrong with the property. Oh, I see I have a question. Let me go to that. Hey, Michael, sorry, can you repeat what the different highlighted parts are? Yes, I would be willing to do that. The red means that there's a contingency related to that particular highlight. Green is something the seller is supposed to do. Blue is something the buyer is supposed to do. And yellow and other colors are just things I felt looked nice when I was talking about it. All right. So back to what does as is mean? As is means that the seller is not obligated to fix stuff. We used to have what are known as seller warranties in the contract, and it would say that the seller warrants certain things. They were going to give the buyer a Section 1 termite clearance. They were going to give the buyer a 1-year leak-free warranty from a licensed roofing contractor. It said all plumbing leaks are to be repaired, any broken and cracked glass is to be replaced, et cetera, et cetera. We don't do that anymore. But as is does not mean that the seller doesn't have to tell the buyer what's wrong. It simply means the seller is not obligated to fix stuff at the beginning of the contract. The property, including pool, spa, landscaping, and grounds, is to be maintained substantially in the same condition as of the date of acceptance. That particular clause, there's a part right there. um, that particular clause is what happens if the property is destroyed, if there's an earthquake and there's a fire and the house is destroyed while it's in escrow. That clause would be used by the buyer to say that they don't have to buy the property because it's no longer being maintained in the same condition as of the date of acceptance. All debris and personal property not included in the sale shall be removed. All right, I've got one right now that's closing tomorrow where I'm coaching somebody, and the seller did not did not take the stuff out. One of the things, by the way, that I told this agent, and I guess I'm going to tell you now, is I often warn buyers not to expect that the house is going to close on time. I know that may seem like a pessimistic attitude, but having done this for a while, problems with the loan, right? And it doesn't necessarily mean there's a problem with the loan, but sometimes the lenders do not send out the loan docs in time to close on time. If you have a loan with Chase and some of the big lenders, I tell my clients do not expect that it's going to close exactly on that day, because sometimes they just don't do the loan docs in time. The other thing is sometimes the seller doesn't move out in time. And that's what's going on right now. The seller's not moving out. Well, so what that we're going to get to the verification of condition. We're doubling in size, and when we get to the verification of condition, the question is, what do you do if the seller didn't take all their stuff out? Right now, the issue here is that the buyer really only has one weapon. Let me see if we've got people commenting. Can you possibly email us the contract, all the highlights? You can download it from the GoToWebinar control panel. It's there where you can see it and download it. So you don't have to, I don't have to email it to you. All right. Make sure you can find it, Judy. But it's there. Um, so what do you do if you represent the buyer and the seller has not fixed stuff or broken stuff or left their stuff there? And the bottom line is, besides yelling at the listing agent, not close. That's really the only weapon the buyer has. We would, as an interim thing, say we want the escrow to hold back. $2,000 was the number we picked this time. And it would be released once the seller has gotten all their stuff out of there. Right. In this particular case, the seller took the washer and dryer, which they were supposed to leave. Well, they brought it back because we threatened them. And then they left with the refrigerator, which they were also supposed to leave. And so now we've asked them to please return the refrigerator. Right. So, well, that's yeah. So unless you like to buy appliances for people, right? If there's debris, now I knew a couple of guys that were very good at making stuff disappear. Right? I have no idea what they did with it. They would come. These were not sophisticated contractors. They would come with their van and they would move things out, right? And it would go away and never to be seen again. This happens more often than one would expect, right? And sometimes if I'm the listing agent, I'm often the one who's found the person to go and take the stuff out. But in some cases, the listing agent isn't cooperating, the sellers aren't cooperating, you represent the buyer wants to move in, and how good of an experience do you want this to be, right, for the buyer? Right. I have this follow-up system where you ought to talk to them the day after, you ought to talk to them the week after. You ought to talk to them the month after. You ought to talk to them 2 months after. And what you ought to be asking them is, everything okay? Are there any problems? What's going on, etc. Right. Some of you have heard me when I talk about home warranties. If you buy one for your buyer, buy the top of the line, everything included, the platinum one, because if something breaks, you want it fixed. What you don't what's going to happen is the friends of those buyers are going to ask the buyer, how was their transaction? And when they say horrible, right, they're not going to say, well, who is your agent? I'd like to call them. Right. You understand? If they say, well, there are a lot of problems, but our agent saved us by coming in and doing all this stuff. And the agent, see, if you keep following up with them after you've been paid, you're communicating that it's not just about the money, right? But most real estate agents, the last time the buyer hears from them or sees them is in the rear view mirror of their car driving out of the title company's office, and the agent is waving to them, and that's it. And by the way, some agents don't even show up at the closing, right? You understand? Because they never had agent. I always show up at the closing. By the way, in our policy manual, I would put in, you ought to show up at the closings, right? I'm not saying that I've never missed one, but I'm just saying you ought, if you would like to get repeat and referral business. By the way, 12% roughly of all real estate transactions are people repeating with the agent, and 40% of real estate transactions come from referrals. You ought to show up at the closing, right? Right. Their law. Right. Right. So you ought to be there. By the way, when they move in, when people move in, I usually have make arrangements for pizza and things like that to be delivered on the day that they're moving, pizza and drinks. Yeah, yeah, well, I'm just saying, if you want them to be happy. Right. Right. So you should just so you realize the contract does say the seller is supposed to get all their stuff out of there. However, there aren't a lot of options if they don't, right, at the last minute. What else? Seller shall, right? So if it's green and this is something the seller shall do, disclose known material facts and defects. Notice that's in upper case, right? I can't tell you how many agents have said to me, "Well, it was as is, so we didn't have to tell them anything." I'm like, I don't know where you got a license, huh? Anything, including known insurance claims, right? Including known insurance claims, right? There's something called a clue report, right? You can call the listing agent up and ask him if they've got a clue. It's a report. It's a comprehensive loss underwriting report that the insurance company will give you about any claims on the property. So do you realize that if you make too many insurance claims, they'll stop insuring you, right? Insurance is only for people who do not need it, right? You understand? If you need it, then they don't want to cover you, right? Right. It's there, but this is something you ought to look at, right? Because if they've submitted too many claims, then you may not be able to get insurance, and if you can't get insurance, you won't get a loan, and if you don't get a loan, you're probably not buying the property. Well, it's usually part if the listing agent is doing a good job, that would be part of the disclosure package up front. But anybody can get one. All right. The loan company is going to insist on seeing it. Buyer has the right to, this is red now, so this is a contingency. Buyer has the right to conduct buyer investigations. Based upon information discovered in those investigations, cancel the agreement or request the seller makes repairs. So even though it's being sold as is, that does not mean that you can't produce a wish list and ask them to fix stuff. Right? I've had agents tell me you can't ask for stuff. It's as is. Most real estate agents have never really read the contract. The seller is advised to conduct investigations of the entire property in order to determine its present condition. Seller may not be aware of all defects affecting the property and other factors. Property improvements may not be built according to code. Oh, really? Or in compliance with current law, or have had permits issued. Now, one of the things that you will want to do with your buyer is the CAR has a form on election of inspections. And that form has every inspection just about that you could elect. I mean, it's a long list. And it would be good to have a conversation with your buyer. Do you want to get a inspection of the roof? Do you want to get an inspection of the chimney, a masonry inspection? Do you want to get a radon gas? Do you want the lead paint tested? Do you want, and so they could say no, 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 yes, no, 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 yes. If they don't want to have inspections, there's a form called waiver of inspections. All right. If you're buying a fixer upper, they kind of expect that you're going to either be a contractor or bring a contractor, right? But they're not expecting that you're going to be inspecting it because they kind of think you've already done that. Buyer's investigation of property and matters affecting the property. This first sentence is the most open-ended contingency in the contract. It says buyer's acceptance of the condition of and any other matter affecting the property is a contingency of this agreement. That is pretty open-ended, right? And any other matter affecting the property. Now, I'm going to have a class coming up after this on counteroffers, contingencies, and more, where we're going to get into this in a little bit deeper as to what it is not a requirement of the contract that the buyer even tell the seller why they don't want to buy the house. The way the contract is written, it's enough for the buyer to say, I've decided I don't want to buy the house. The issue is there's a clause in the contract that says that any contingency, any actions really taken by the buyer and seller in the contract have to be in good faith. So it's possible that the listing agent, the seller might say this wasn't a good faith, and they're going to press you for a reason. Now, although the contract doesn't require a reason, you need the sellers to consent to get your deposit money back. And the seller may be slow at consenting unless they have a reason. So when we talk about in the contingency class, I'll talk about how to get out of a contract using this clause without getting in trouble with the listing agent. Some years ago, I had a transaction in Blossom Valley. The buyer bought the property. The market was softer than it is even now. They did not have appraisal as a contingency, but it didn't appraise. So they wanted to renegotiate the price, and they wanted to use this sentence as the way to back out. And the reason they gave me for wanting to back out was there wasn't enough room in the backyard for a kidney-shaped pool, and that the 3-car garage was really 2.5. Now, these are not good reasons, right? You understand, because they saw the backyard when they looked at the house. They walked through the garage before they bought the house. I wanted to say to the other agent, you guys aren't even trying, right? You understand? You're not even trying to come up with a good reason. They drove by at night and it sounded noisy on the street and rough-looking characters were walking around. Who can disprove that, right? You understand? They checked the school rankings and didn't like them. They checked the crimereports.com and they find that there's crimes in the neighborhood, right? You gotta not just say something that's obvious. So when we get to the contingency class, I'll talk about more about how to actually use that. Then in blue, it says buyer shall have the right at buyer's expense to conduct inspections, investigation, tests, surveys, and other studies. These are the buyer's investigations. And then it goes through and gives you a list. You can come, I've had asbestos inspections, radon gas inspections, right? I've had people bring in psychics, ghostbusters, and Native American shaman. Right, all you have to do is be in the business long enough, and yeah, feng shui is commonplace. The guy that stood out in front, he actually has a ghost busting thing, and fought with the evil spirits to get him out of the house, right? And by the way, when a buyer says they want to do that, I said sure, absolutely, absolutely, right? No problem, right? Yeah. Yeah. So anyhow, if you do it long enough, you don't get surprised anymore about these sort of things. It says that the buyer shall neither make nor cause to be made invasive, destructive buyer investigations. That means you're not supposed to rip things apart. What that also means is oftentimes on a termite report, and even sometimes in the property inspection, they're going to say, we don't know what's behind that wall, right? We don't know. And you would have to make a special test, right? You'd have to say to the seller, we want to see what's behind that wall or we're not going to buy the house. Green means seller shall make the property available for all buyer investigations. Buyer shall complete these investigations and remove the contingency or cancel this agreement. So seller has to make the property available for all buyer investigations. It doesn't actually say whenever the seller wants to, or if the seller wants to, or, it says all investigations, right? And it says that you shall, if you're the buyer, do this, remove the contingency or cancel the agreement within the time period specified, which are coming up. Give seller at no cost complete copies of such investigation reports obtained by buyer, which obligation shall survive termination of this agreement. Which means even if they've canceled, they're still supposed to give them a copy of all the inspections and reports. By the way, there's a question. No, I'm not going. There's a question about the appraisal, right? Whether it is is the appraisal report one of those in buyer investigations, inspections, or reports? The appraisal.
It's not up to the buyer whether or not you have the appraisal done.
Well, it's up to the lender, but once the buyer has it and the buyer's agent has it, are you supposed to give the seller a copy?
I don't think so.
Right. How about this? You don't have to, but you might want to. Right. Recently, I had a transaction where appraisal was not a contingency and it appraised for $100,000 under the list price, under the sale price. Right. But appraisal was not a contingency. However, we got the seller to pay half. No, no, we got the seller to pay half. And the reason, the first thing I did is I sent the listing agent a copy of the appraisal. And then I told the listing agent, this may be a gray area, but I told the listing agent that now that you guys have a copy of this, this will become one of the investigations and reports that's part of the transaction history of this property. And if you do not, if we cancel and you sell it to somebody else, you're going to have to give them a copy of the appraisal up front. And that's going to probably affect the willingness of a buyer to pay the price that we agreed to. And so you're going to have to deal with the fact that it didn't appraise. You could deal with us now, or you could deal with it later. Why don't we do it now? We'll take half. And they agreed and we closed. Some lenders, but few of them, actually have rules that say they don't want to make the loan if it doesn't appraise. Most lenders simply say you have to come up with the difference in cash. Right. So, and that's a whole different, if you remove the appraisal contingency, you need to go through this with your buyer. Right. And so, for example, if you do this, you would say to the buyer, you realize it's $1 million is what we're offering. If it appraises for 975, you have to make up the $25,000 in cash in addition to your down payment. Is that okay? If they say, sure, we'd do that. I would then say, how about 35,000? Would you do that? And they say, we'll do that. How about 50? What if it appraises for 950? Are you willing to do that? They're like, oh, I guess we would. How about 925? Now, there's a point where they're going to say, no, 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 no. Right? No, right? I'm not, I don't, I can't, I won't. So it's
And you have that conversation
when you're writing the offer.
Okay, so you're saying that's
part of the conversation, right? Right.
Okay.
If we're removing appraisal as a contingency,
yes.
right. And by the way, I've helped agents with offers recently where appraisal was not a contingency. One of them, that's the one that's supposed to be closing soon, was in Milpitas. There were 10 offers. You understand, it was back in the old, just like it, well, 2 years ago. There were 10 offers. And the buyer, you have to have the conversation with the buyer. How bad do you want to own this house? And the guy said, bad. I really want to own this house. So we went through if we make appraisal as a contingency, the chances are if there's 9 other offers, you're not going to get this house. I'm just saying that's the truth, right? You're not going to get the house. So is it possible to put in a clause that says the property must appraise for a minimum of? So if you take the offer price and the buyer tells you what their maximum amount they would be willing to throw in, you subtract that from the offer price and at least you could put in a floor, right? You understand, this is safer, right? This is safer, right? And if the listing agent thinks it's going to appraise, what's the problem, right? And they always, yeah. So I'm just saying you need to, why was that? Yeah. So you give them a copy. Seller shall have the water, gas, electricity, and all operable pilot lights on for buyer's investigation. Seller shall. D says buyer shall keep the property free and clear of liens. Buyer shall carry or buyer shall require anyone acting on buyer's behalf to carry policies of liability, workers' compensation, and other applicable insurance. Now, the reason I've highlighted that is if the buyer has a handyman friend do something, and they get hurt and they file a workers' compensation claim, you understand you've got problems, right? You have problems. So this is why it's usually better to hire like licensed contractors, property inspectors, and other people that actually have insurance. I'm just saying. Defending and protecting seller from liability for any injuries to persons or property include during buyer's investigations or work done on the property. The notice of non-responsibility says, and you shouldn't be getting into this, But the notice of non-responsibility is a form that would be, this is if you're letting the buyer in early to fix stuff, right? Which is generally a no, right? But although who knows, right? I've had times where we've done that. I'm just saying, right? But what the problem would be, what if the buyer brings in somebody to fix something, the buyer doesn't pay them, the buyer doesn't close, the person that they brought in to fix something files a mechanics lien. A notice of non-responsibility is something that an owner can file within 10 days of obtaining notice of the work being done that they're not responsible. Generally, you do not want work being done until they own the property. Title investing. Buyers shall be provided a current preliminary title report. Buyer's review, red means it's a contingency. Buyer's review the preliminary report and any other matters. And any other matters which may affect title are a contingency of this agreement. Any other matters. So recently, this was a fun one. The agent the home is listed by the list. I'm helping a listing agent. They get a preliminary title report. Buyer's agent gets the preliminary title report. Title, of course, has a preliminary title report. Lender has a preliminary title report. In the preliminary title report, there's a hyperlink where it says the deed, where you can click on it and go look at the deed. The listing agent did not click on it and go look at the deed. The buyer's agent didn't look at the deed. The um, lender did not look at the deed, and the title company did not look at the deed at the time of this, right? And it turns out that this property was purchased 30 some years ago through the Santa Clara County Housing Trust. Now, what happens apparently if you look at the deed is it says that. So the agent that I'm coaching called me up and said, what's the deal with this? And I said, my understanding is after 20 some years, 23 years, something or other, that you can sell the property. But let me look into it. And I was wrong because that rule is for the Silicon Valley Housing Trust, not the Santa Clara County Housing Trust. And their rule says you can never sell this property without selling it back to them. We're in escrow at this point, right? We're in escrow at this point. Now, the agent felt really bad. She's a meticulous real estate agent. And I admitted to her, I said, I don't click on that link and read the deed, right? I have, by the way, ever since. I've started to take a peek at the deed just to see if there's anything funny on it. But you get the idea. You might want to take a peek at that. And they eventually found it after like 2 or 3 weeks in escrow. Yeah, they eventually figured it out. Right. Right. But you just, so that's that would be something to look at when you get the prelim. And the title companies do classes on how to read a prelim, right? You ought to go to one. It wouldn't be a bad idea because this is a contingency of the agreement. I've had transactions where there was on the deed reference to an easement, right? And I eventually was talking to a high tier lawyer at the title company, right? A underwriter for the title company as to whether or not they were going to insure the title based upon this easement, right? This is something you might want to look at, and any other matters which may affect title, right? You understand? It goes beyond just the prelim. As I 40, we get to 14B, the company providing the preliminary report shall, prior to issuing a preliminary report, conduct a search of the general index of all the seller. And anyhow, their seller shall, seller shall within 7 days give escrow a completed statement of information. I missed that seller shall, but that's so they can do the prelim. Sometimes there's judgments against them that they don't know about at the prelim. Does that make? Let me make. I guy in Redwood City says he wants to sell his land. I list it. I get a preliminary title report. I look at the preliminary title report. It looks like all the preliminary title reports I've seen. There's nothing there. Turns out that a judgment, he had been sued in San Diego 5 years before by a business partner, and the business partner won and got a judgment against the guy and recorded it in every county in the state. Right? They always do. They always do. They always do. Right? If your lawyer is any good, they record it everywhere they can, because they didn't know where he owned property. He had a common name. They just okay. Now the title company figured it out, right? At some point, right? So yeah, that's why they want the statement of information.
So would that be a judgment against just that property?
No, a judgment is a general lien, which is a lien against any and all property owned by the person in that county. And it also means that they could come up to San Mateo County and get a writ of execution and force the sale of the property. And the judgment would have to, the seller said to me, he said, well, what does it mean that I have this judgment? And I said, when we sell the land, you're going to have to pay off the judgment. And I'm not going to use his exact language, but he expressed a disinterest in his business partner getting any money. Right. And so he decided not to sell because he was going to just outwait. All right. Within the seller shall disclose, let's say, title is taken in its present condition, subject to all encumbrances, easements, covenants, conditions, restrictions, rights, and other matters of record or not of the date of acceptance, unless buyer is assuming those liens. So all of the monetary liens of record which seller is obligated to pay should be paid off. Within the times, this is C, seller has a duty to disclose all matters known to seller affecting title, whether of record or not. So if you're representing a seller, by the way, and the seller says to you, should I mention that there's a dog down the street that barks at night? The answer would be yes. Should I mention that the kids down the street vandalize cars? The answer is yes. I had a seller say, well, when I'm walking in with my groceries and my neighbor is washing the car, he's turned the hose on me. Should I mention that? And I said, yes. Right? Do you understand? And just about anything that somebody thinks of, then that's a selling point. Right?
So that's an interesting thing. I wish I would have known that. I've had my house for 20 years in Gilroy. And two things. My heater / air conditioning is the loudest thing I have ever heard in my whole entire life. And it's the only thing I hate about my house. And I've tried to have it fixed, and it's not fixable. And I hate it. I absolutely hate it.
Right.
And I wish I would have known if I would have.
And did it make that noise when?
Well, the property inspector should have turned it on and made a note.
Yeah, you should have turned it on.
Right. And in the verification of condition, you should turn stuff on. Right. You should turn things on. All right. Buyer shall seller anyhow. Sellers are to disclose any title things. Buyer shall receive a.
With that, going back to that one you were talking about, that 36-year.
Yeah.
That thing, wouldn't the seller have known that it was under that contract?
Yes, but the seller wasn't sophisticated and didn't understand that at 30 years, it's been over 30 years. Right. They thought it was their house. Wouldn't you? And I can sell my house, can't I? And the answer is no, actually you can't. All right, a buyer shall receive a CLTA/ALTA homeowner's policy of insurance. You could choose another policy if you can't get that. That combined CLTA, which of course you all know stands for the California Land Title Association. It is what's known as the standard policy. Most title companies use the upgraded American Land Title Association, the ALTA policy, which is an extended policy. And it covers a whole bunch of new stuff. You ought to, by the way, go visit a title company when they're talking about this stuff, right? They're very friendly and will be happy to meet with you. Believe me, very friendly. Time periods. Removal of contingencies, cancellation right. The following time periods may be extended, altered, modified, or changed by mutual agreement. Any removal of contingencies or cancellation under this paragraph must be exercised in good faith and in writing. Remember the exercised in good faith. The seller has 7 days after acceptance to give the buyer all the reports, all the stuff. If by the time specified seller has not done that, then you just don't cancel. You have to give them a notice to perform, which is a 2-day notice. If they don't do it in 2 days, then you can cancel. Now, if they know what they're doing, they have all this stuff in advance, but they don't always have it all. They're in a hurry to get it on the market. I'm showing property right now where I have to check. Today, we should have the reports. My buyers would have bought it on Sunday, but they wouldn't take offers on Sunday because they don't want them all contingent, and they've got the inspections done, and they want so it would be, I think, wiser to do the inspections before you list the home than to do them after you list the home, because, well, you get the idea. Buyer shall have 17 or whatever. Now, there's nothing magical about 17. If you listen to the California Association of Realtors legal webinars, like I do, then it means you have no social life and a low threshold for entertainment. And or you're an insomniac or something. And what they say when you ask them why 17, they said, well, some of them people wanted 21, and some of them wanted like 15, and so they picked a date and they picked a number in the middle. Right? Usually we write in something else, right? Because it usually doesn't take 17 days, but it could, depending upon what kind of inspections. I'm showing property. I have a buyer lead also, just for fun, I guess, Ben Lomond area in Felton. Right, I'm showing property in Ben Lomond and Felton, and some of the inspections up there, there's no city sewer. They've got septic tanks, they've got wells. Right, you understand this could take a little bit longer to get all that done. So we would usually put in maybe 12 days, something like that, 10 days. You can get an inspector out relatively quickly, but I would generally, you'd put in a number that would work. I like, if I have a bunch of contingencies, for them all to be due at the same time, simply because I'm lazy. I mean, time efficient, and I would rather not have to keep track of 4 different days. I would rather know that this is the day. And, so you have, let's say, 12 days. That's just an example to complete all buyer investigations. Now, an interesting issue is, let's say the seller has given you a copy of everything in advance, and you are in your 12-day period and you find something that was mentioned in the disclosures that they gave you before you wrote the offer. Is it possible to use that as a reason to back out based upon this contract, or does it have to be something new that you discovered after you are in contract? You don't think it has to be new? If you're the listing agent, what would you say?
Well, if there's a listing agent,
It would be that. Right. And so the listing agent, and I have to admit, if I'm the listing agent, I would be saying, well, if this is good faith. I had another agent that I'm coaching. The listing agent happens to be an attorney, right? In addition to being the listing agent. And the buyer wants out based upon something that was in the stuff. And so the listing agent, the attorney slash listing agent, is telling the buyer's agent, who I'm coaching, that it's not good faith. That if you're given the disclosure prior to writing the offer, you have constructive knowledge of all of that, and you can't use it to back up.
detailed, it may or may not be.
Well, that was based upon what was in the report. What I did is I help, one of the things I do when I'm coaching people is I help them write emails, particularly to lawyers and listing agents. And what I emphasized was this part of that paragraph. What I emphasized was the phrase review all disclosures, reports, and lease documents to be assumed by buyer. Review, review. Right. All right. And I challenge the listing agent. We could go get a dictionary and look up what that means. But and as a practical matter, could the disclosure package include the homeowner association documents? 500 pages long. Right. And you understand, you haven't read it all. Right. And so I challenge the listing agent / lawyer to show me where in the contract it says if we give you a copy of something in advance, that's no longer a way to get out. Show me where it says that. Right. I've read this form many times. It doesn't say that. But it does say that we can use those 12 days to review all disclosures, report all. Right? Isn't that what it says? Review all. Right? I'm just saying. Right?
What did they get out of it?
Yes. We got the deposit back. Right?
Yeah.
All right. Yeah. Yeah. Anyhow, I've had some experience writing these emails. So I'm just saying now it would be better, however, I'm just saying that if you thoroughly go through the disclosures in advance with your client before you make the offer, because it's a lot easier to do it that way than to try to pry your deposit back from the listing agent, right? And have me write a threatening email to them, right? I'm just saying it would be a lot better if they already knew in advance and understood it. Seller complainer delivered to seller signed copies of all statutory and lead disclosures and so what this is saying is that during that 12 days which we put in, you're supposed to sign all the stuff and get it back to them, assuming you haven't done that in advance. Buyer may request that seller make repairs or take other action. We usually don't ask that they fix stuff because the lender's not going to like it. First of all, now you could do it without the lender knowing about it.
Gonna do the cheap way. Right?
Yeah, you don't want the lender to know that the seller's fixing stuff.
Oh.
Ask your loan agent a hypothetical question. Ask your loan agent, tell the loan agent, I have a hypothetical question. Right? If I had a buyer and you were making the loan and we were in a transaction and we wanted the seller to make repairs and that were on an addendum, do you want to see a copy of it? This is a hypothetical question. They're going to say, don't send that to me. Right? They don't want to see it. Right? Because they don't want a discussion of repairs. So we often are more likely to ask for a credit.
So that's the main reason. That's the main reason that you want the credit issued.
The other reason is the seller doesn't want to do it during escrow either.
Right. The seller doesn't want
Right. And they would rather it be done after they've moved out. Right. And then you get a credit and then the loan agent doesn't need to know.
Alex, didn't you have an agent who the buyer wanted the seller to make some kind of repair and they canceled the deal because of it? They canceled the sale. I mean, somehow they got out of it. Does it ring a bell? Like,
but it was.
Maybe it's more involved in that. Yeah, it may have been, but
it was.
But I've heard more.
It involved the swimming pool, and the swimming pool wasn't working.
Yeah.
And the seller said no. Right.
No, the guy said.
And the whole thing
All
fell
right.
apart. Yeah.
So I'm going to highlight one more thing here. Seller has no obligation to agree to or respond to buyer's requests. Right?
But if it's a request in the form of a counter offer.
No. So what we would do, this isn't a counter. We're talking about we're in contract.
All right, we're in contract.
Right. I have one of my classes. I go through what's the difference between an addendum and amendment. Right. Which is. We're not. Well, that's an advanced class. We'll talk about that. The point is that it said in a previous line that within the contingency period, the buyer was going to remove the contingency or cancel the agreement. Now, I've heard other opinions about this. My approach is I would, if we want the seller to fix stuff, and let's say, what they say, Friday, let's say Wednesday is the contingency removal date. I would be talking to the listing agent now about it, right? And what I typically do is send them a copy of the report that says there's an $8,000 plumbing issue. That's what I was talking to an agent about last night. And give them a little bit of time to absorb it, right? Because most of the time they go through the stages of grief, right? Denial. There's nothing wrong with my plumbing, right? Anger. God damn it, those people, what are they doing? They're lying about my property. Then they go through all the different stages, and finally there's acceptance. All right, well, we'll split it with you, right? So I've heard other people say, you wait to the last minute, make an amendment, and send it to them and put them under the gun. I hope there aren't backup offers, right? I'm just saying, right? But I would rather start a little early to let them know what we're going to do so that we're not fighting. Because if you don't do it on the contingency day, they might give you a notice to perform, which we're going to talk about in the contingency class, which gives you 2 days. And if it's the agent is on it, they'll give you the notice to perform 2 days before the contingency removal date, which means they can cancel you if you do not remove the contingency on that date. Why would they do that? Why would they do that? They have a backup offer, and they just as soon you go, right? They just as soon. All right. So by the end of the time, the buyer shall deliver to seller removal of the contingency or cancellation. However, if any report, disclosure, or information for which seller is responsible is not delivered, then the buyer has 5 days. So if they haven't given you a natural hazard disclosure statement, by the way, you get 10 days with that. You get 10 days with the lead-based paint, but you get 5 days from the delivery of other stuff from the seller. So even if you've removed the contingencies, but they haven't given you a prelim, which is unusual, or they haven't given you something, you have 5 days from when they give it to you, no matter what this says. Continuation, if nobody does anything, what happens? And the answer is we continue limping along, right? It doesn't destroy the contract, nothing, we just keep going. Even after the end of the time specified in 14B1 and before seller cancels, buyer retains the right in writing to either remove the contingencies or cancel this agreement based upon a remaining contingency. Once the buyer's written removal of all contingencies is delivered to seller, seller may not cancel the agreement.
Where are you right now? 'Cause I'm lost.
I'm on paragraph 14B4. So it's today is contingency removal day, and we don't remove our contingencies. And the seller does not give us a notice to perform. It's now the weekend comes and goes. It's Monday. We have not removed our contingencies, nor have we gotten a notice to perform. We keep limping along, right? We can still cancel because we have not removed the contingency, but we don't. What I'm saying is that the contingency doesn't expire at the end of that time period. It has to actively be removed, right? There's a difference between active and passive removal. Passive removal means that when you hit that day, if you haven't done anything, it's gone. That's not the way the contract is worded. Somebody actually has to do something. Access to the property. So this other one that's about to close, they didn't have a termite report, but the buyer wanted the property really bad. And so the buyer bought the property without a termite report. They wanted it really bad, but the buyer wanted to get a termite inspection. Listing agent, who by the way is also a lawyer, says to the agent I'm coaching, you can't do it. The seller doesn't want you to do a termite inspection, and you don't have a contingency, so you can't do the inspection. So I copied paragraph 14B5, and I had the agent, I wrote the email for her to send, and it says buyer shall have access to the property to conduct inspections and investigations for 17 days. This is a place that hardly ever gets changed, right? We might be writing 12 days up here, but I've never seen an agent write in another number there. After acceptance, whether or not any of the contingencies have been removed or waived. In other words, just because we don't have a property inspection contingency does not mean we cannot inspect the property. right? It says we can inspect the property up until 17 days, which, by the way, was about the time it took for escrow to close. Removal of contingencies. I'm going to do a class on contingencies where we're going to talk about that. Seller can cancel if a buyer does not either remove the contingency, well, does not remove the contingency within the time period. Seller, after delivering to buyer a notice to perform, can cancel this agreement. And we're going to again spend more time on that in the other class, but seller, after first delivering to the buyer a notice of buyer to perform, may cancel the agreement if by the time specified buyer does not take the following actions. And then there's a long list of things that the buyer could be forced to do with the notice to perform, right? And we're going to go through what the notice to perform looks like, when you would use it, all that stuff. You might have to give the seller a notice to perform. The sellers in this transaction have not signed off until today, right? We can't get the loan docs because the seller hasn't signed off. There's sometimes when the seller needs to do something, but that's rare. Effect of buyer's removal of contingencies. If the buyer removes the contingencies, the buyer has assumed all responsibility for those items, right? It's not well, and I'm just saying. Close of escrow. There's a demand to close escrow form, and I'm going to go through that when we get to the contingencies. The whole idea of counteroffers and contingencies is its own special class. Notice of effective cancellation on deposits. What this is saying is that if the buyer backs out and the buyer doesn't have an open contingency, the buyer would lose their deposit to the seller. That's what it says. This, by the way, is not an automatic thing. It doesn't just automatically get transferred to the seller's bank account. The only way that money is going to leave escrow is if the buyer signs a cancellation form, which the buyer generally does not want to do unless they get their deposit back. The seller is not going to be able to sell it to someone else while it's still in contract and escrow is still open. They need the cancellation form. I'm just saying, right? If the market is a dropping market, however, and the seller is losing money because the buyer backed out, you've got problems if you represent the buyer. If it's a rising market and the buyer backs out, arbitrators generally won't let the seller keep any of the money because they make a profit because the buyer backed out, they sold it for more. Right, and I know what the wording of liquidated damages says, that it's like, it seems like it's an automatic thing. It's not an automatic thing. You have to go to arbitration to get the money. And the arbitrator isn't necessarily going to let the seller keep the money just because the buyer missed a contingency. They don't act that way, right? It's just been my experience. But it says that if a party is fooling around in bad faith, in addition, they might have to give up $1,000. Final verification. We get this, there's been a lot of issues with this. Buyer has the right to make a final verification of the property within 5 days prior to close of escrow. I get this question a lot from new agents. They will I get a text message or a call, and the agent is like, I'm in zip forms. We're doing the walkthrough. I can't find the walkthrough form. And I hear them, they go on and on about how long they've looked and how hard it is, and there's no walkthrough form. And there is no walkthrough form, right? The form is not called a walkthrough form. If you go to zip forms and you type in the word walk, you're going to find nothing, right? It's called verification of condition. Type in verification and you'll find the form. Now, this, as it says, is not a contingency of the agreement. The agent, by the way, in this other one wanted them to do the walkthrough. This is the another lawyer / listing agent who didn't want them to do a termite inspection, wants them to do the verification of condition the day of closing. Right? That day. Right. And I'm seeing a pattern here in which is that they're afraid the buyer isn't going to want to buy the house. What if the buyer moves in and we talked about this personal properties there, something is broken. You don't have a lot of options. You can not close. Right. You tell the seller, we're not closing until you fix the stuff. That is usually not what the buyer wants. Right. You can say, we'll hold money back if the listing agent seller says, no, we don't agree to that, now what do? You're back to option number one, not closing, right? But then say, we're going to hold money back until you fix the stuff. You can close and sue them in small claims court, which again is not something that the conversation I had last night with this agent was, your buyer doesn't have to actually sue them. The buyer just has to convince the seller they're crazy enough to do it. Right? You understand that they're that angry, and by the way, if you go and file, which doesn't cost that much, they usually start to talk to you because they're like, oh my God, these crazy people are taking me to small claims court. Right. But you understand you don't have a lot of choices. It says here, this is not a contingency of the sale, but it's something your transaction coordinator is going to want to see if you use one, and you should have in your file.
Well, small claims court, you can get a judgment against them, but trying to collect.
It does. There are people outside of the small. There's people outside of small claims court that'll give you 50 cents on the dollar for your judgment. I've never personally been sued in small claims court, but I represented a company. I was the guy that talked to the lawyers, and the company, every time you sue a buyer or seller, sue each other, they include the agents. So I would go to small claims court. I've been there many times representing the company. Right. And it's when you walk out, they have like vans with little tables and things like that. And they'll say, bring us your judgment. We'll give you 50. And they're bill collectors.
That's what's happening in Palo Alto. Apparently, every time a multi-million-dollar house closes, there's a suit.
Oh, I don't know about every, but there's a lot.
Often.
Yeah.
Anyway, often.
Right.
And then vans come up and they open the doors.
All right.
I sued somebody in small.
I'm going to power through this. Let's start. Repairs, you should be doing them during escrow, but if you're doing them, they ought to be done by licensed contractors and all this other stuff, right? It doesn't actually say that here, but that's prorations of property taxes and other items. I'm not going to get into that here. Compensation and scope of duty, this broker paragraph, this is something you can read if you have. Yeah. Oh, sure. That's it.
When you have to do prorations and everything on property tax, who does it? The
title company.
Oh, the title company.
Escrow company.
Because that was like my little area.
It's escrow companies. Okay. Real estate agents generally do not need to get involved in that. The one thing that people need to know is the buyer needs to know there's going to be a supplemental tax.
Okay, because my old realtor who I used to work with, he'd do all that. I mean, he'd get as close as he could.
Well, I used to teach agents how to do that, but that was a long time ago, right? There are these things called escrow companies, right? And they have software. By the way, they have an app you can put on your phone, right? But anyhow, yeah, and there's this statement here: property will be reassessed upon change of ownership. There's actually a disclosure form about supplemental taxes. Compensation, I'm not going to get into what the brokers are doing in this. I'm not really. It's basically saying, let me summarize this. What it says on the MLS and what it says on real estate agent flyers is not necessarily true, right? I'm boiling down that paragraph, right? I'm just saying. And the statewide buyer and seller advisory gets into that in greater detail. Representative capacity would be if the buyer or seller is a trust or a LLC or something else. The joint escrow instructions, I don't generally spend a lot of time with this when I'm talking to a buyer, right? But basically this is saying that this is going to be the basis of escrow instructions. And I don't even bother to write in the name of the the escrow company. I just don't do it. But this I'm going to point out because it's an educational thing. Brokers are parties to the escrow for the sole purpose of compensation. This would be a shock to many real estate agents who think that they are in charge of escrow. I've had agents say, I'm going to tell escrow not to close. And I'm like, who are you? Right? What do you mean you're going to tell escrow? Right? You're not I don't know what and then there's going to be the rest of this. If you're unclear because you're new about this, talk to a friendly title rep and they'll meet with you. If you've never met a friendly title rep, you sit in the office long enough, or just they'll walk in eventually, right? Go to any realtors meeting, stand there and look friendly, and people will walk up to you smiling and chat with you. Guess what you've just met? You've met a title rep, right? They'll meet with you and they'll go through all this with you. Remedy, yeah, I've had agents say, "Where would I meet a title rep?" I said, "You're not trying if you need to meet a." Remedies for breach. This is what liquidated damages is, and it says if the this is a whole nother class, right? About this, I'm not going to go, but basically it says that the buyer could lose their deposit if they do not close and they don't have an open contingency. Right. And the California Civil Code says if it's 1 to 4 units owner occupied, it can't be more than 3%. Right. Now, this could be interpreted to protect the seller because the seller
Get
get
the earnest money amount.
right. Well, but it doesn't have to be.
Right.
Right. My original part one of this, which you can get a copy of for a nominal fee, I go through that. I've already saw an agent today, a listing agent, put in the MLS that they're willing to take an initial deposit of less than 3% if they increase the deposit to 3% on removal of contingencies, just like the good old days, right? And so I think when you're going to start seeing that the 3% up front was when it was a hot seller's market. When it becomes more of a buyer's market, yeah, why give them all your money right at the beginning? Wait till contingencies remove. This also could protect your buyer.
Right.
Because let's say the property went down in value $100,000 and they breached, they could be liable for the difference, right? You understand? Whereas they would only be liable, let's say it dropped 5% in value, they would have been better off with 3%, right?
And the market changed in a certain amount of time, or what happened?
So you make an offer for $1 million,
Right.
it appraises for 900,000.
Okay.
Your buyer doesn't want to buy.
Right.
They did not initial liquidated damages. The seller could sue them for $100,000. The loss as a result of the breach, if they sell, when they turn around and sell it for that. Mediation, arbitration. Don't spend a lot of time on this. My explanation is mediation is marriage counseling. You do not have to do what the marriage counselor suggests. Isn't that right?
True.
Arbitration is divorce court. You have to do what they say.
Yeah.
By the way, in Santa Clara County, all these things would go to arbitration and mediation. Anyhow, the difference is if initialed here, arbitration results are binding. That means you cannot appeal it in a court. That's the difference. It'll be binding. But all of these would go to arbitration in Santa Clara County anyhow because they don't, just because.
Okay, so
What
we
is
don't want, okay, so we want these initials, correct?
generally a lawyer would give you advice, but I would say this listing agent is expecting that you initial these, and it could save you money. What is not included, by the way, is any matter that is within the jurisdiction of probate, small claims, or bankruptcy. You can always sue them for up to $10,000 in small claims court, even if you've initialed this. Preservation, selection of service providers. We do not guarantee the performance of any vendors, right? We don't. We just recommended them. Multiple listing service. We report things to the MLS. I've had buyers say, can I have the MLS take away all the pictures? I don't want anyone to see the pictures. I want the pictures off the internet. Good luck with that. All right. You understand? The pictures, by the way, belong to the MLS and they're not going to delete them. You can write an email to Zillow and ask them to remove all the pictures. But you understand. Good luck. Attorney's fees. Whoever loses is supposed to pay the other one's attorney's fees. Assignment, buyer shall not assign any or all parts of buyer's interest in this agreement without first obtaining separate written consent of the seller to the specified assignee. So I'm just saying, the agents sometimes write in name of buyer or assignee. Well, it would be better to use the CAR AOAA form, which is an assignment agreement form. Terms and conditions of the offer. Time is of the essence. Let's just mention something there. Essence here comes from a French word that means at the heart of the matter. That means if it says you have until 11:59 on Friday to remove your contingency and it's midnight when you do it, technically you did not do it in time. But you have to understand, if you're on one side of the transaction and you keep missing all of the deadlines yourself, they're not going to let you cancel the other side because they missed one too. You understand? As soon as you let it go without writing an addendum, changing the time, right? You understand? If you and the other agent just say, well, we'll do it next week, it won't be a big deal, and you don't do an addendum to modify, there's a change of time addendum, right? If you don't do that, then you're basically saying time periods don't matter to us. By days, do we mean calendar days or business days? And the answer is calendar days. We do mean calendar days. The only place that it says business days is the 3 days to put the deposit into escrow. All other days are calendar days. We're going to talk more about that. If escrow is going to close in 30 days and we signed the purchase agreement today, is today day one or is tomorrow day one?
I guess today is day one.
And the answer is tomorrow is day one. That is G, days after, means the number of calendar days after occurrence of the specified event, not counting the calendar date upon which the specified event occurs. This is why I prefer a close of escrow date, not 30 days. Because I've noticed that usually my counting is different from the other agent's counting. And then we're like, what day is it? And then expiration of the offer, you should write in here where it says or by. Does everybody see that? Your name. So let's say you're the agent representing the buyer. You put your name in there. And what this is saying is that delivery to you constitutes delivery to the buyer. If you do not write in your name, then delivery means delivery to the buyer. The listing, if I'm the listing agent, I don't like that if this is blank. In fact, if you leave this blank, this is a form I'm going to discuss when we get to contingencies. There's a form called the DNA form, which is a form that virtually no real estate agent has ever seemed to have heard of. Yet it's a zip form, which is called a delivery of notices addendum. Because, well, we'll talk about that when we get to
delivery, and I thought you just skipped right over it, but now I see that you didn't because you worked it into the expiration of offer.
Right.
Because delivery is a big deal.
Right. Delivery of acceptance, it's communication of acceptance. Right. It says if you don't do anything, they have 3 days. Right? It says the third day after this. Now, you should be, are there multiple? So you should have a conversation with the listing agent before you write this. And the conversation should include, when will you be able to present the offer? If I give you the offer today, when can you present the offer? And if they say tonight, don't give them 3 days. If you were the seller, how long would it take you to decide if you were going to accept our offer? Yeah, like 3 minutes. Right. You'll say, how much? I say 1,025,000. You say no. Is that, you know? Or yes, right? You know, I mean, they don't need 3 days. And what happens if you give them too many days is they'll shop your offer. Sure. Right? And by the way, I covered in the previous one. If you read the PRBS form, which is attached to the beginning of this, the possible representation of more than one buyer or seller, you're going to see a paragraph near the bottom of that form that says your offer is not confidential. That's what it says. No, PRBS. What is that? The possible representation of more than one buyer and seller. I don't know that I've ever caught that. It's in. It's all the. No, I know. I just don't know that I recall that. I know. That's why brokers are. Do you understand that a broker is essentially paid? Do you understand a broker is essentially paid to be a broker because they've read the contract, right? 90% of all the questions are answered in the contract. Right. And, you know, real estate agents are, even some of them are good at filling out the contract, but they've never read the contract. That paragraph says that this is not confidential. Is there a confidentiality agreement you could include with it? Why not, if you wanted to, right? It's just not a common thing. But the buyer needs to understand that their offer is not confidential unless there's a confidentiality
When
agreement.
there's multiple offers, I mean, it's, you don't have to answer it now, but at some time I'd like to have a better feeling. I always been curious about this, how much information is shared and how is it shared?
Well, I'll tell you what I do. So I had a listing where the offer was, we'd listed it for 999,888. Why not? Which was 200,000 lower than I thought it would sell for. First offer is 1,048,000. Another agent calls me and says, "Do you have any offers?" I said, "Yes." He said, "Well, I don't know if you're willing." I said, 1,048,000. He said, "Okay," and we had an offer for 1,075,000. Another agent called me and I said 1,075,000. And then we got an offer for 1,100,000. Right. Well, I wasn't lying. They all knew they all knew that I'd priced it low. It eventually went for 1,110,000 to the buyer who started at 1,048,000.
Oh, wow.
Right. They eventually,
Below what you thought
and I just kept working it up. Right. But you understand, if there's multiple offers, the listing agent, it says in the listing agreement that the listing agent is authorized to disclose the number of and amounts of any offers received. It says in the possible representation of more than one buyer or seller that this is not confidential. My job as the listing agent is to get the highest price possible for the seller. I understand there's differences of opinions about this, but the one opinion is if you don't tell anybody anything, then somebody might guess a higher number than you would have got by telling them. My experience is being I want them to keep adding and adding and adding and adding and adding, right?
And then you have to respond to, let's say you have 5 multiple offers, you have to keep them alive, you have to respond to all of them.
Well, you have to do it within time period. Anyhow, so I've gone a little bit over. Have I lost everybody for going over? So what the acceptance and all this, there's not much to see here. What we're going to do next week, right? If you guys are happy to do this next week, I'm going to do the class on counteroffers, contingencies, and more. That's what it says, and more. And we're going to go through some of the specific parts of this. And then eventually we're going to go through some of the other fun addendums and things like that. But that's enough. I gave you guys extra. I'm not going to charge you any extra for that. If any of you are online interested in discussing ways of increasing your production and getting more hands-on individualized training, let me know. I'd be happy to talk to you about that.